All right, folks, we are going to get moving.
Yep.
Everyone online, thanks for joining. If you came to watch a fun-filled talk about succession planning for attorneys, you're in the right place. If not, this is the wrong webinar for you. You got to do this disclaimer right here, right? For the non-lawyers in the room, get a lawyer. We're not your lawyers. For the lawyers in the room, same thing, but you probably need less of a disclaimer. This is my dear friend and partner Lou Licata. Lou is on. Just a quick introduction of both of us and who we are and how we got here. Seasoned lawyer, board certified, lots of good ratings and reviews. Lou and I actually met in Entrepreneurs Organization, where Lou had previously served on the global board. And another fun fact, Lou and I have both been on the boards of Cozy. Lou was the former chair, and he is obviously an avid traveler. So Antarctica is the only one left for you, right?
Right.
All right. That's going to happen. I feel like that's going to happen.
It was supposed to happen this year, but we'll get there.
Yeah. This is me. I've been doing this a little bit less than Lou, but not too much less. I was before starting this firm, before merging with Lou, I had my own firm. Before that, I was general counsel for a while for a telecom company. Spent some time in Iraq and got some nice awards as well. And so Lou and I are the dynamic duo behind our firm, Gertsburg Licata. We do everything that a business could need. Most of it we can do in-house, corporate litigation, probate. Occasionally we will come across a matter that requires us to reach outside to our network. We generally bring them in as opposed to sending our client to someone outside the firm. We work closely with specialists like patent lawyers, tax lawyers, but for the most part, we are a one-stop shop for our clients. We also have a few affiliates. Our clients come here for not just legal advice, but to work on their M&A strategies. We help them find buyers and sellers of other businesses. We help them with recruiting. And our newest venture is a tech-enabled legal audit called Cover My Six, which we're pretty proud of. And just recently, we won the Crane's Best Place to Work award, or we're on that list anyway. I'd like to think we're the best place to work.
We are.
Okay, this is our agenda. We're going to blast through this as relatively quickly in the time that we've got. You could easily spend all day doing a deep dive into each of these topics. We're going to kind of do an 80-20. We're going to hit the things that we think are most critical to understand and to issue spot. Lou and I have been doing this, as I'll explain here, as we'll talk about in a second, both for ourselves and for our clients now for several years. And so we are here if this talk is too high level, and if you have more questions afterwards, call us anytime. So Lou, you want to go? Why don't you start, Lou? This is a good story. How did we meet?
Oh boy. So I'll try to give the short version. I always had a list of lawyers in the area that I thought would be good people to talk to about collaboration or joint ventures. My firm was a smaller firm that I used more of an outer ring of strategic alliances, and Alex was on that list. And lo and behold, it's like when people's names keep popping up. Lo and behold, his name popped up that he joined EO. And so we went out for coffee one day. EOS, by the way, the Entrepreneurs Organization, which is a global organization, 17,000 members that are all owners or founders of their business, with revenues of at least $1 million. That's the criteria to be an EO member. We met, went to coffee, and I felt like I was talking to myself, 15 years ago. Like the things that Alex was doing was the things that I had tried to do or did 15 years ago. We both had similar philosophies, similar core values. I mean, like it literally was like talking to myself in a mirror in some respects. And so we started working together and decided that it made sense to merge. And so we did. And this story is a little bit about that process because as you can tell, I'm only a little bit older than Alex, not a lot, but enough to where I was starting to look at my succession plan and trying to decide, well, what do I do? I mean, am I going to just one day decide I don't want to practice law anymore and close my office? Or am I going to land? And I talked to some larger firms. Am I going to bring my book to a larger firm and then just fade away? And my ideal situation was to find a like-minded partner who I could grow together for those last 5-10 years of my succession. And then the firm would basically be a continuance of what I had brought to the table, what Alex brought to the table, and whatever else came to the table as a result of both of our efforts. And so Alex will share with you the process we went through, because we went through literally from the time we decided we should merge to the day we merged. Within 3 months, we completely merged every aspect of our business, and we bought a building to boot. And the relevance of that is that if part of your succession plan is to roll your firm into another operation, another entity, these are the things that you'll need to deal with to make that successful. So I think that's about all you need to know, I think. Does that cover everything?
Yeah. We wanted to start with the story because Lou and I have done it. Everything that you're about to see comes from considerations, charts, templates, processes that Lou and I have personally gone through. And at the end of this, I'm going to show you the deep dive into this chart. This became, when Lou and I merged, among the reasons we were able to make it happen so quickly. Number one, we're both deal lawyers, right? So we were doing these deals for our clients for years. We took these checklists and templates that we had used with our clients and customized them for law firm mergers. And then we built this nice Gantt chart. And then it was like pretty much clockwork. As soon as we decided we wanted to merge, we populated this chart. And this is what our recommendation is to any lawyers thinking about merging with another firm. We populated this chart. We turned the ignition key. We assigned a who to each one of these elements. And then we just started meeting. We met every single week for about 3 months, with very few exceptions, for about an hour. And it was basically just who is doing what part of this chart. And it went really smoothly as a result.
Yeah.
So we're going to dip in and out of our story throughout this talk, but everything starts at the beginning, right? So before you even merge or sell or transition your practice, you've got to have certain considerations that you want to address and think about.
Yeah, I think that this really goes to starting early about what you want to do in the last 5 to 10 years of your practice. I mean, you could do nothing. I've seen some lawyers do nothing, and they just don't wake up one day and their firm is sitting out there and it's a colossal mess trying to figure out like who's going to manage the clients and the cases and the matters and the employees, where do they go? And I mean, that's like just the wrong. I mean, doing nothing is just a disaster. And even if you don't, if you just decide at, some point in time, let's say you're 75 and you're like, you know what, I'm done practicing today. If you haven't given this any thought, it is an unbelievable undertaking to close down a firm. And we will not get into those aspects today. We're not going to talk about closing down a law firm, but you can imagine with all the obligations you have with respect to client files, client relationships, confidentiality, file storage. I mean, whatever it is, to be able to pull the plug just does not occur easily. There is a lot of planning, practice, execution that goes into that process. And so what we're going to talk about is a way to make it less painful, so that you'll be considering something other than hey, I don't want to practice law anymore. I'm just going to stop today, because it's just not possible for you to close the doors and walk away. So one of the things that we suggest in this sort of trail is to start early and be proactive. You really want to start this thought. I probably should have thought about it even sooner, but my timeline was pretty good. When I was 55, I started thinking about, okay, when do I want to retire? Where do I want to go? What do I want to do? Is there anybody in my firm who's really there to take over? Should I go to another firm? And that's the number 2 part of identifying and developing potential successors. There's always the opportunity, if you're doing it soon enough, to have sort of the apprentice model, where you've got the lawyer who's worked for you for 20 years. They've learned your way of doing business. You trust them with your clients, and you slowly but surely transition out, and they transition in, and they take over, and they basically just keep running the firm in a way that's successful and profitable, with their own spin. Or you can do it externally, which is to look for firms or other practitioners that would be a good fit for you to roll your practice into their practice. This can be done by a merger. This can be done by an acquisition. Those are just names that identify the nature of the transaction. The reality of the situation is that you are taking your practice and combining it with some other practice, which may or may not include your continuation in that new venture. I was young enough and early enough in the process where Alex and I are going to continue practicing law together, but our goal is to develop our firm and bring in more people and have success. And we already, as we'll get to later, have a succession plan, but we still need to build out the people who execute that. And the other part of the best practices is to continue making sure that the client relationships and the continuity of those client relationships are easily transferable to wherever you go. There will be clients who will not be excited about moving their business to a new venture or to a different arrangement. But for the most part, clients are our clients because they trust us and they believe in us. And so as long as they know they're going to be taken care of, if I can look my client in the eye and say, you know what, I'm not going to be working on your files as much. I'm going to have this young guy who's a superstar work on your files. I'll oversee him. That transition starts very early in that process. You want to keep those relationships and continuity of those relationships intact. And then comes the comprehensive transition plan, which we'll get into the details of. And last is the communication and involving all the stakeholders. And those stakeholders are not just clients. So for example, Alex and I merge. What do we do with our IT vendors? He has an IT vendor. I have an IT vendor. We have to decide which makes the most sense going forward. We come up with a plan. We involve those stakeholders in that conversation, and we move forward accordingly. So we're going to cover some of these in more detail, but this is really the starting point for thinking about it. Then the other thing that we have to weave in here, because it really goes, you'd be surprised how many of these transactions proceed without even any awareness that there actually is an ethical rule governing in Ohio. It's Ohio Rule of Professional Conduct 1.17. This rule is modeled after the ABA rule. So there are rules at the ABA level that you can look at. And most states have some version of these rules for the purpose of selling a law practice. Typically, the sale of a practice was prohibited. But the changes occurred with the idea that it was better for the clients to have a smooth transition in the handling of their legal matters than it was to leave the clients to their own devices and trying to find new counsel. There were some other factors that went into it, but the bottom line is they adopted the model sale of law practice in 1990. In 2003, the Ohio Supreme Court adopted a rule 1.17. And then we get to the local rule, the current rule now of 1.17, which is a little bit more complex than the ABA model. Let's go to the, yep, you're there. Thank you. These are the key components of the rule. We're not going to go through every aspect of it, but this surprised me when I first read it, because the entire practice, 100% of the practice must be sold if this is a succession in the form of just transferring your practice and retiring. It's a little bit different if I'm going to continue. And I'm going to basically merge my firm in or become an acquired entity. It can be less than 100%, but for the most part, the rule is that if you're selling your firm and you intend to exit the practice of law, 100% must be sold. There are confidentiality requirements that have to be met under this rule, as can be imagined. Both in terms of protecting client confidences and other aspects of the information that's being transferred. You'll need a purchase agreement. The rule requires it to be a written agreement. The rule requires all clients must receive written notice of the sale, and they have the opportunity to object to continue. The purchase agreement must include the intentions of the purchaser, that the client's existing fee agreements and will transfer and be honored, and that any restrictions to the seller's right to practice have to be fair and reasonable. So what you don't want is a situation where somebody sells you the practice and then they go out and hang a shingle and start practicing all over again. So there are restrictions that are permitted, but they've got to be reasonable. And in most cases, what we found is that people aren't looking to continue practicing law. That's one of the reasons why they're going through this succession process. Part of the entire practice does include goodwill. And the exceptions to the 100% rule is obvious conflicts of interest. If in merging our firms or in the acquisition of, let's say, my firm, there were conflicts where Alex could not, as a firm, represent clients that I have, then those clients would not have to be included as 100%. And the most important one is there's no flipping. You cannot buy a practice and then resell it or split it up and resell it to other groups. So, the 100% rule, I can get around that. I'll buy your entire practice. Now I'm going to sell your probate practice to this probate firm down the road, and you can't do that. The purpose of this rule is to permit a transition of a retiring or exiting lawyer's practice into the firm so that those clients can be handled and maintained without any real problems, in a seamless and successful way. Let's go confidentiality. Well, obviously there's confidentiality relative to the, this is just like an acquisition, right? So you're going to enter into some kind of an NDA because you're going to have to exchange lots of information that's confidential, not only the client relationships, but also the financial components, the hourly rates, vendors, timekeeping. What kind of billing system do you use? What kind of accounting system do you use? Are these systems compatible? The opportunity to discuss those are only going to be successful if you have this confidentiality in place so you can talk about everything. The timing is an obvious one. We've seen deals that just go too long and die. And if you go too fast and don't think through some of these, you'll wreck the car. You'll just have a mess once you merge. The biggest problem you'll have will be literally trying to get bills out to try to get paid for your services. If you haven't done this successfully, clients will be getting no bills, or they'll be getting bills that are all they're so confusing and they're so erroneous that you just won't get paid. And it doesn't look good, and then the clients are unhappy. I mean, the number one priority here is keeping the clients happy. That's always the case. And these preliminary discussions, the timing and the scope of these obligations, all are relevant to making sure that that happens.
Just a quick
Jump
tag
in.
on what Lou said. Yeah. So the NDA that the parties are going to sign are there to protect their businesses. But it becomes an ethical issue the moment you disclose client confidentiality, including potentially the names of the clients, without their consent, without an NDA. The NDA, the rules of professional conduct basically say, look, how you treat your business is really up to you, but how you treat the clients is the ethical issue.
Yes.
So the timing of your NDA must be early enough so that it covers the clients prior to you disclosing any information about them.
And the rule specifically says that the confidentiality agreement between the parties has to treat those clients as if they're your clients to begin with. So that's a big responsibility. So if you and I are talking about acquiring the firm, we signed a confidentiality agreement. We now have to treat each other's clients as if they're our own. And we have to protect all of the confidences relative to those clients. It's a pretty broad responsibility. Let's go to the, we've covered the entire practice must be sold. So let's go to the mandatory provisions. The good faith, it's an interesting that they require this. The rule actually requires a good faith statement in the agreement that both the seller and the purchaser must basically represent that this is in good faith with the intention of delivering legal services to the clients and others who may need legal services without the intent of basically reselling any of these clients to another party. So it's just kind of a interesting, like you would think that would be the case, but this mandates that you actually address and make those representations into any agreements. The next is the notifications to the clients. This is, as you can imagine, this is really important. It's important, aside from the ethical requirements, it's important for the success of the business. When we get into valuation later on, and you're going to pay a price for the book that you're buying from the retiring lawyer, you want to make sure that every one of those clients transition to your firm. And the only way to make sure that happens is not even from the ethical side, from the business side, is through good communication. I recently talked to a partner at a big law firm, and we talked about succession, and her interest was more internal to the firm, right? Because big firms have a lot of succession triggers and components. But when I asked her, I said, you know, if I had to communicate one thing to everybody about what's the importance in the succession process, what would be? She said communication. The communication process, starting with the clients, is critical, and moving all the way down to all the stakeholders, employees, the parties involved. It's just the number one indicator of success. And so the notice to clients required under the rule is that there's a shared obligation by both parties to make sure that a notice goes to the client and the client's consent to the transfer of their legal work to the new firm. There needs to be in this notice requirement the date when this will become effective, the fact that the existing fee agreements will be honored, that the billing rates in place will be maintained, the client's rights regarding other counsel and files are the right for them to take their work elsewhere. You have to tell them you do not have to go to the new firm. You can go out and we will transfer those files. There'll be no interference with that decision if that's the decision. And then to the contrary of that, the clients have to actually give you consent, but it doesn't have to be signed. We recommend getting signed consent on those letters, but it's not required. It's just presumed with this letter. So if you send the letter, and again, this is because the courts have recognized that the Supreme Court has recognized that sometimes there are deadlines, and if you're waiting for a client to consent, their legal matter could be jeopardized. So if you send this letter as required and the client does not respond, it is presumed that they've given consent. And usually, if you're not going to ask for a signature, you should ask in the letter, you should state, excuse me, in the letter that we will consider that you are agreeable or have consented to this transfer unless you contact us. And anybody who's going to be working on the matters for the new client, it's required to give them information about the lawyer's bio, professional qualifications, and if there's any disciplinary issues historically. So it's a real full disclosure to the clients about who's going to be taking over their matters. And then the delivery of those notices, you have to have some verifiable method by which you deliver. I don't like certified and registered mail. I prefer, I mean, this is important enough. We have lots of ways to deliver notices now, especially if you're requiring a signature. You can do it in email via DocuSign. You can do it hand delivery. You can do it, mail with proof of service, things like, there's lots of ways to do it. People don't like signing for like certified and registered mail. They might think they're being sued, so they don't sign for it. So the key here, and obviously in most of these cases, the client's getting a phone call first. Hey, just want to give you the heads up. This is what we're doing. You're going to get a letter from us. We'd appreciate it if you could review the letter and get it back to us. Or if you have any issues, give me a call right away.
So, and this probably goes without saying, but I'll say it anyway.
Yeah.
Everything we're talking about right now is based on the Ohio rules of professional conduct.
Yeah.
If you are watching this and you're not in Ohio, your state is going to have different requirements. In Ohio, what Lou was talking about with the presumption, it's a 90-day presumption. You have to put in the notice that your consent will be presumed if I don't hear from you within 90 days.
Yep.
I have no idea what New York's is or what other states notice presumptions are or objection presumptions, but check it.
Yeah, the most important thing is to realize that you have to do it and then figuring out what the checklist requires. These are the other considerations. Again, common sense, but I'll just knock them out real quick. Limitations on liability. Nothing in the transaction can limit either side's responsibilities for malpractice or professional responsibility. There can be limitations of liability on non-legal aspects of the business. You can also have in the limitations of liability provisions for indemnification, so that if the acquiring law firm catches a malpractice suit based on the former law firm's actions, that there can be some form of indemnification or impact on the fees that are maybe the purchase price and the fees that are being paid out. Let's see, what else was there? The transactions for the sale of disappeared lawyers' practice. When there's remember I gave you the scenario where I just check out, like one day I don't wake up and now somebody's going to take care of my practice. All the obligations that would normally be on the seller and the buyer now become solely the buyer's responsibility. And then the competency is that all lawyers who are responsible for the acquisition of a practice have to satisfy the competency requirements of the rules of professional responsibility. They all have to have all of those abilities to conflict clear, get client consents, competence to assume representation. So it's really the same kind of rules that are imposed on if you're acquiring a new client. And then the fee ranges, we've already talked about that they must be honored, but there's two parts to this that the Supreme Court really emphasizes. One is you cannot increase fees to finance the sale and charge those to the client. So I'm going to pay you $500,000 for your book. and then I take all your clients and I spread that $500,000 across the clients and increase all their fees to pay for that. That's prohibited. And although we are required on the purchasing side to honor the current and fee engagements, it does not prohibit ongoing matters to be renegotiated. So corporate matters, where, you know, I'm charging $300 an hour and the acquiring firm is charging $400 an hour, my fee agreement will be honored, but that does not mean that at some point the acquiring firm cannot go back to the client and say, we need to renegotiate the fees. We charge $400, you were paying $300, and the client then has a right to leave. But that's where we at on those requirements. I think we've reached a CLE code point.
Yeah, so the last year that the Browns won a championship, this is it. So to get CLE credit, you have to type this code in to the chat and send it to us so that we can report that you've been awake and paying attention. So do that. There's one more coming up with another piece of sports history. This will be educational for multiple reasons. Okay, documentation. So before you have a suitor or an actual human or firm ready to take over, we recommend putting a succession plan in place so that you have predictability, and if something happens to you, you're able to point somebody, whether it's your trustee or your executor or someone else, to a document that will be able to transition your clients and their matters to a new person. And that document doesn't have to be so specific that it even names who the new home is going to be, so long as it at least identifies who the transitioning party is. At minimum, we call that a triage lawyer. At minimum, somebody should be able to wrap their arms around your clients and their cases if something happens to you. And obviously, if you want to get really intentional and plan beyond just something bad happening to you, plan for an actual orderly transition, orderly succession. That's what this document's for too. Your estate planning documents need to contemplate that there is this succession plan document in place. That's where you tell your executor or your trustee to go check out this succession plan document. And then if you have a merger or a sale or some other firm or lawyer taking over your practice, well, if you've done any M&A, this is a pretty standard track, right? It all starts with an NDA. You go to an LOI where the material business terms of the transaction are spelled out. It doesn't have to be binding. Most LOIs are not binding. Then you negotiate a definitive purchase agreement. You're doing diligence on each other while you're doing that. You're creating ancillary documents like employment agreements, transition agreements, consulting agreements, a bill of sale if there's a sale of assets, etc. Then you have a closing, and then you have documents that are triggered after the closing, and those are prepared kind of as the ancillary documents. So what's a succession plan? This is it. It's instructions. It's you telling somebody what you want to happen with your clients in your practice. Your absolute basics, and I'm going to flash onto the screen just briefly, just so you could see what a succession plan looks like, and you'll see that all of these elements are at least contemplated in it. Basically, what we advise is have your estate planning documents contemplate your succession plan documents, and vice versa, if possible. You'll see that Lou and I signed our succession plan, I believe, as our trustees of our estate plans. So let me just show you what one of these documents looks like. It doesn't have to be scary and complex. It is basically just like who is doing what and when, so that your clients can, okay, here it is right here. You'll see this is our succession plan, right? It's 4 pages and a signature page. And so here's where we appoint one of our partners to manage the succession of the firm. We have an advisory committee. Here's where we talk about where the books and records of the firm are. And that's it. And then here's some signature pages, right? Signed by Lou and me as the trustees of our trusts. And then here are some schedules that tell Connie, in our case, and also the trustee, who the clients of the firm are, what are the bank accounts, IOLTA, passwords. That's it. It's pretty basic. That document right there will create a tremendous amount of comfort, security, and predictability, not just for our clients who should really care about what's happening with their matters, but for our employees and for our families, so that they don't have to fight over or look around for all of this critical information. Okay, back to the PowerPoint. So as I said, all this stuff is in there. When you get to the point about who your successor ought to be, okay, it's got to be someone that you trust, someone who's got a lot of experience. You don't want this to be someone right out of law school, right? This is obvious. It's got to be someone who's competent, with an established record of client service, okay? If you are going to sell your practice, you want to make sure that the new firm is compatible with your culture. We've seen a lot of deals go south. The numbers were great. The acquiring company is paying top dollar for the selling company, but the culture is just totally clashed. One was an employee focused comfort. We break bread with each other's families every month kind of a firm, and the other firm was just black and white, surgical. We just care about the dollar. We're not going to really get too cozy with clients and with employees, and that deal went south really quick after closing. So culture is super, super important. And then there's this concept of a triage lawyer. That's where you identify a lawyer whose job it is to simply move the practice in the event of your untimely demise from where you, or if you suddenly become incompetent, from where it is to its new home. And you're basically giving that lawyer power of attorney and general instructions about the kind of place you want your firm to land. Your succession plan ought to have client and matter information, security credentials, accounts, etc. Make sure that your bank accounts, credit cards, IOLTA, all have transfer upon death instructions to your bank. And this is, I mean, it seems so silly, but management of your website, your social media, your email, you want to make sure that that's an easy transition, because God forbid something happens to you, and now somebody's got to come in and they got to start talking to Google and to GoDaddy and to different IT providers to figure out how to get into your email. That is a disaster. That's a disaster. Your bank will have forms for you to fill out to make transition of your IOLTA and other bank accounts easy. And as I said earlier, every state has its own rules, especially IOLTA. You want to make sure that your successor and your succession plan have very clear locations and instructions regarding an identification of who your agreements are with, where are the agreements. It should be super easy to find your insurance policies, especially your malpractice policy. And where's everything located? Where are your dollars, your investments, your assets, and identifying key employees and what they do for obvious reasons. Then you go to your estate plan and you want to make sure that it's updated, your will and your trust, contemplate and call out your succession plan. You want to make sure that whoever you've identified as your succeeding lawyer or your triage lawyer is identified in your powers of attorney, because that lawyer is going to have to go to your bank and start transacting business on your behalf, and your bank's going to say, show me the power of attorney. You want to have instructions to your family to give so that they recognize your triage lawyer, your succession lawyers, and you want to make sure that the estate planning documents identify locations of important documents and files. Lou, I'm going to turn this back over to you to talk about the actual sale of a practice and considerations about it.
So the transitioning to retirement. Yeah, got it. I just noticed the slide. I wasn't sure if we were on the same slide. Yeah, so we actually talked a little bit about this. So I'm gonna jump through this one quick. We talked about basically your options of closing, or one, just closing your office, or two, recruiting an internal successor, or three, merging or selling your practice. Those are the three. We've talked about them at length. Obviously, the benefits of a sale are the opportunity to maximize really your goodwill and value in that. And we'll talk about the valuation process in a minute. And the considerations are, at this point, just become like any other transaction. Are you selling your assets? Are you selling a stock? The ownership, and what are the ancillary documents? So you'll need the documents to transfer your interests in your firm to the acquirer, regardless of whether they're just an asset transfer or whether there are other ownership interests, like the stock sale or the LLC member interest share, member interest transfer that are being sold. So here's what we found a lot of times. The parties get together. Yeah, I want to sell my practice. Great. How much do you want? I want $1 million. That's 1 times revenue. Okay, fine. And I'll help with the transition. I'll stay on board for a year. And I'll help the transition because I want to make sure that I get my $1 million. The $1 million is going to be based on that revenue coming in over the course of, let's say, 3 years. And so you'll pay me out 35% of all the revenue that comes in over the course of the next 3 years, and from these clients. So you're structuring the deal. Well, what's completely ignored in that process is, well, what am I doing with all my office furniture and my software and books and just the things that are normally property that would otherwise be transferred in an asset or stock sale? So a lot of times you might have to have an assignment and an assumption agreement that makes it clear the tangible and intangible assets that are being transferred, which might also include a bill of sale to transfer the tangible personal property. And even if you're talking about property, meaning real property, like the building you own, or maybe just the lease that's part of that. These are all parts of the deal that I've seen lawyers just casually ignore when they're just having the conversation about, yeah, I want to retire. I'll sell my practice. You could buy it. I'll come over for a year. It really is a little bit more complex. It doesn't have to be complicated. It just means that you've got to make sure that you check the right boxes to get to the right result. Then the post-sale retirement we were just talking about. If you're going to continue working, let's say I want to. I mean, we acquired one lawyer, for example, and he wanted to keep working for 2 years. Okay, great. So we have an employment contract with him. What's his status? In this particular case, he's considered to be a senior income partner. And then what are the parameters of that compensation package? Now, we've just bought his book, so we're not going to double pay for the book, but we are going to pay him for work he does. And it's to his advantage to make sure that all those clients transfer work to us, because his payout over the course of time is directly tied to our success and ability to bring in the revenue from those clients. And so all of that should be basically documented in some form of either employment agreement or partner agreement or success consulting agreement, whatever you want to call it. So let's go then to, oh, we got another CLE code.
Yeah. Anyone know the significance of Lou? Do you know the significance?
Well,
of
I know the
this?
significance. I mean,
Of course you. This
Oliver,
is. All right, Lou, you go. What?
well,
Share.
that's the last time the Indians won the World Series.
Right. That's
Yeah.
right.
The Indians are,
1948.
they're not the Indians anymore. So I don't know. Does that mean that they don't exist anymore? So,
Yeah,
um, let's get to the last leg of this, and then we'll certainly have time for any questions or for any chiming in. And Alex, please jump in. The biggest question, and this is really interesting because Alex said to you at the beginning that we do this for our clients. We also do this for ourselves. We have acquired several books of business or practices, and the issue or discussed the acquisition that did not proceed. And the issue is always, how do you value the practice? And so we've done the work and research. And as a professional service firm, and you can look this up, there's plenty of articles out there on the internet. There's actually an expert that used to work for one of the big comp and acquisition firms that all the lawyers paid attention to. And this gentleman, who I don't mind sharing his name, Dan Connerman, Dan has this belief that you never, first of all, you never pay money up front for the acquisition of a firm or the book of business. And two, that the rule of thumb is somewhere between 0.5 or a half of 1 year's revenues to 1.5. And that the key considerations in that end up going to what is the profitability on these clients. So, you could have $2 million worth of business, but the profitability of that business is only 10% net incomes. Thank you. And that's not going to be a really successful acquisition for $2 million, because you're going to have to make sure that, first of all, you get every dollar of that $2 million in the door, and that you service it the same way, and that it's the most efficient servicing, because you're only going to get 10% on the end. And how you pay that out over time could also offset that 10% because of the time value of money. That's why you don't pay it up front. The asset-based method is also a way to look at this. That's where the value is assigned based on tangible and intangible assets, such as receivables, phone number, proprietary software, existing WIP or contingency fee arrangements, other non-goodwill assets. This is used where a firm has significant tangible assets. They're tallied, the liabilities are subtracted, and you have a net value. This focus ignores the firm's earnings and cash flow. So this is not a favored method, but it is a method. There's a discounted cash flow method. And this looks at the firm's projected future cash flow using the financial statements and the previous 5 years as a basis. This is a way to say, okay, we think this much cash is coming in, so we're in a position to pay, half of that or some portion of that, 35% of that back out to purchase the practice. There's certainly market comparisons, but what we've seen and what we think is probably the biggest driver is the ability to have revenue that the firm can count on, that will be profitable, that will have a margin, a net income margin that is really successful, because otherwise it costs money to transition the practice and service the practice. And if that cost is absorbed by the very thin margins, then it's not really worth it to the law firm and could be a loss.
Just one thing from my own experience, and Lou, I know you've seen this too, in non-law firm M&A deals, which has definitely carried over into law firm deals. Very often the seller overvalues their business.
Yeah,
it's a personal and emotional assessment that they're making. They've spent their entire career building this practice, and the buyer more often than not is going to be objective and conservative and see dollars and cents over the emotion of it. And so bridging that gap between what the seller thinks their business is worth and what the buyer is willing to pay, well, that's the whole game.
Yep.
Right now, if you can't bridge that gap in just pure dollars and cents, there's other levers that you can pull, right? So just as an example, if seller is willing to pay less than what the buyer is asking for, but is willing to pay for a longer period of time, right? And the buyer is going to, I'm sorry, and the seller is going to stay involved in the business and is going to have close client relationships and transition. If the seller has confidence that they're able to get the benefit of the bargain to the buyer using their own efforts and relationships and transition time, maybe they wait a little bit longer to get what they're looking for up front. So there's different levers you can pull, but there's definitely, in our experience, a gap there that has to get bridged fairly early on.
Yeah, I think, you just in your explanation, it made me realize that we might have just not overlooked, but not given enough attention to the scenario where the lawyer isn't going to retire today. They're going to retire, let's say, in 3 or 4 or 5 years. And so when they bring their book over, they're not getting paid for their book at that point. What they're getting paid for at that point is compensation based on how that firm compensates its people who generate revenue. So, for example, if we pay 30% to the lawyer for working that file and 20% for bringing that file to the firm, they're going to get that 50% payment if they bring it and work it. They're going to get that 20% payment if they let somebody else work on it. And they're going to get 30% on matters that they work on for our clients. But when that person then steps out in 5 years, says, okay, you know what, I'm done, I want to retire now, the benefit of coming to a firm that is willing to buy your practice, really what we're talking about is a retirement tail. And so in those scenarios, all the clients that have been brought can continue being paid generation as a retirement tail for 3 years. It could even be as long as 5 years. It just depends on what deal you strike, and how much guarantee there is for those revenues to continue coming in. So I think that's the most likely scenario. We see this a lot. I'm going to bring my book. I'm going to have a place to work. I can spend the next 5 years building it, making money. This is my last hurrah. And then, as I exit, I'm still receiving revenue because I built a nice book for the firm that they're buying from me in the form of a retirement tail. And that can be structured in a lot of different ways. It could literally be structured as a buyout, which then, might have different tax treatment. There's a lot of ways it could be handled, but those are the considerations. The last thing I'll just hit real quick is these other key value drivers, which we've talked about or alluded to, but I'll just point them out. What's the financial performance of that firm? How profitable are they? What are their expenses? What's the ratios? Things like that. What's the growth potential? We know for a fact that firms that we've brought or practices that we've brought in, we've been able to maximize the potential because we offer services to those clients that former lawyer or former firm did not. What's the brand identity? How much brand awareness is there with the lawyer or the firm that's being acquired? The size of the practice? How repetitive are the client revenues? What are the fee structures? How much reliability is there on the recurring revenue? What's the practice structure and owner involvement? What are the client satisfaction elements? The practice areas, the diversity of the client, all of these things go into value. So these are things to consider and not to overlook on both sides of the table. The person bringing the practice to the new firm and the new firm's acquisition of that practice.
So we've got about 2 minutes left. I'm going to spend the next 2 minutes just showing you our timeline. We are really proud of this. This is the culmination of years of doing M&A deals that really, I mean, it was just kind of, it all came full circle when Lou and I, two deal lawyers, just took our work product on doing other people's deals and put this thing together. There was almost no argument. I don't think there was any argument about what needed to happen, right? But one thing I will say before going into this, bring your accountant to the table. If you've got a controller, bring logistical people to the table so that you don't have to do all of this yourself. If you've got an HR manager, Lou and I had a team of 5, 2 from Lou's firm and 1 or 2 from my firm. And then we also brought in an accountant / consultant who had a lot of depth with law firm mergers, and they were at the table for most of the meetings. We aligned on vision. We determined here's some screening that Lou and I wanted to do. We identified how we were going to create accountability charts, organization charts. We went through what we were going to pay each other and our team, what the employee benefit plans were going to look like, what the bonuses were going to look like. Here's your formation considerations, right? What kind of entity is it going to be? Are there going to be affiliated companies? What are the tax considerations? Here's, is this going to be a new company or a merger, an A+B=C merger? Then you had marketing. We had our marketing director at the table. And then you had technology, all of this stuff. And then what you'll see at the top, right? The merger was completed when column D here said done in every single one of these, right? In the planning phase, we had a person's name for each item in column C. And then we figured out, all right, well, if we wanted to, I think we decided, Lou, that by April 1, we wanted this closed.
Yeah.
We started in January. So we basically worked from the end backwards, put April 1 closing date, and then just intuitively created the timelines what are the gating issues, identifying which issues you need to hit first, because if you don't hit them, everything else is a waste of time. Right. So that was mostly corporate formation stuff and compensation stuff. Right. And then here's accounting and billing, trust accounting, billing procedures, reports. This is really, it covered everything. And then the other thing we did is there's a tab here at the bottom for these are vision exercises, right? And we actually developed some of these later after our merger. We were in the process of acquiring or merging with another firm, and we added another tab here to make sure that we were fully culturally and vision-wise aligned about what we wanted to do with the new company. So we went through this, determined that we were in fact fully aligned, and then went back to the other chart. And then this guy right here is really important to figure out who how in a divorce one guy gets the furniture and then the spouse gets the TV, right? This is basically an inventory of who everyone's vendors are and then what the conclusion was going to be. This is where we put in each vendor's terms with each of us and what the relationship was like with them. And then we decided, and we had no argument here either. I mean, this was with some of our vendors, one of us had a really long, deep relationship of trust, and in other cases, no one really cared. It just made purely financial sense. Yes. So that became very important. This logistically made it very, very easy. Yeah. I believe that's actually the last slide. It is. Yeah. So we are at time. I would love to open it up for questions, but go ahead, Lou.
Yeah, I was gonna say, do we have the number, the CLE number for everybody?
Oh, well, there was just the 2.
No, those were the check-ins. We have to give them the,
Oh. Yeah. That's a great question.
I have it. Hold on. I'll find it.
Oh, you had, that's right, you had that certificate. Yeah.
Here it is. So the number is 522622. Activity code 522622.
Perfect. So,
The activity is called,
folks,
just in case, just if you're sending this in, it's called Succession Planning for Lawyers, Tips to Successfully Transition Your Practice.
folks, we are available if anyone has questions afterwards. Find us. We're also going to send around some materials that would be helpful to you, that we alluded to, the ethical rules, some articles, some templates. But give us a call if you are thinking about transitioning or acquiring another firm. We can help be a sounding board for you. We've done it, and you know, in some cases, we could be your transition. We could be your succession plan. But in any case, we are here to serve and to help. So don't be shy. We are doing this again in October with the Cleveland Metropolitan Bar Association. So if you were taking copious notes, but not copious enough, and you want to come back and hear this one more time, the CMBA will be putting this out. We'll be doing this again live in October. Thanks, Lou. Thanks, everyone.
Thanks, Alex. Thank you, everyone, for attending.
See ya.